we're going to go ahead and get started. Thank you everyone for joining us this afternoon. Today's episode of our webinar is The Line That Doesn't Move. We're going to be looking at the new Washington State estate tax law changes that went in effect of the 1st of July of 2026. And I would like to just show you how those may impact you. So what we're going to cover today is what actually did change on the 1st of July, why the new $3 million line is currently not set to rise, what Washington actually counts as your estate, why married couples can't borrow the federal rule, the rule for portability, and when a plan signed under the old numbers deserves another look. So we're going to see if you need to be considering a change due to this change in the law here. We're going to be about 45 minutes. We will have time for questions. So first of all, let's start with what's going on. The new tax law went into effect the 1st of July. The big headline news that was in the papers was that this was a change from the high of 35%, which started on the 1st of July 2025. So for exactly 1 year, we had tax rates as high as 35% here in Washington. And now we're back to the rates that we're more accustomed to, the rates that we've had for decades now, and those are the rates between 10 and 20%. The other big news, though, that wasn't quite as publicized was the fact that the exemption actually decreased in value and went back to $3 million. In addition, that line will no longer be indexing for inflation. So one of the big fixes that was helpful of the 2025 law was that we did get indexing back on, which we're going to discuss and look at today. And so there was some question initially when this was going through the legislature and when it was initially signed by the governor, whether or not there was going to be this was going to actually not have indexing in. But the Department of Revenue has finally come out with their full rules on this and position on this, and they say it will not adjust. So we will not be seeing indexing in the future. So let's just kind of look a little deeper at this, what was actually going on here. So at the beginning of this year, on January 1st, we actually got an index on the inflation or on the exemption from the 2025 number. And so it went up to $3,076,000. That's really what's changed. So as of the 1st of July this year, that number has gone back down to $3 million, and those rates have also gone down to 10 to 20%. So when we are preparing estate tax returns this year, we're looking at exactly at when the person died, and we are using the appropriate exemption. And so it's a little bit of a gotcha because you may not recognize when you're preparing those that there was a change in that number, but that's something that we are looking at when we're doing estate administrations currently. So one of the things is, wait a minute, so what's the big number? What's the one we should be paying attention to? I think that the exclusion, this is the line we're really talking about. And how you can think of that is if your estate value, your total estate value that will be taxed is less than the $3 million, less than that exclusion amount, then you're not going to have to file a return and you're not going to have estate taxes at all. The rate schedule, though, this is where we actually are calculating the tax. And so this is based on the value of your estate as it goes up in value. You know, we're going to see you go up into higher and higher rates. So this the rate reduction is important for people with larger estates, and that's one of the things that they have been focusing on. But the exclusion itself is something that is more helpful or more determined for folks right around the $3 million or $4 million range, or in some of the lower brackets as we're looking at it. And when we think about a married couple, with proper planning, you're all going to be able to double up that exclusion. So a married couple can protect, $6 million, but they may be seeing those rates at the beginning, up to from $6 to $10 million, for example, will be still in the lower brackets, and then those brackets will start to increase after that, and that's where the rate schedule is coming in. We're going to look a little closer now at really the history of this and why that line doesn't move. Initially, when we got the first estate tax here in Washington in the early 2000s, we were given an exemption of $1 million, an exclusion of $1 million or $2 million, excuse me. And from there, it was indexed for inflation. And so that indexing kicked in and brought us up to $2.193 million. And we were using that number for quite a while because it stopped indexing in around 2018. And there had been no more indexing after 2018. And so what happened after 2018? Well, we did get a bunch of inflation. And so inflation hadn't been a big concern for many years. It had been very low, but then we had a few years where it really started to kick in. And we did not get an indexing on that. And so if you remember that time, and if you had come into our office during that period, we would be looking at that issue with you and kind of illustrating how, because that exemption hadn't been going up or that exclusion hadn't been going up, your estate was it was now taxable by the Washington state. I just want to point out here that the rate brackets, the brackets from where the new rates go in. So when it goes from 10 to say 15% or 15 to 16% or so on, those brackets have stayed the same for more than 20 years. And they do not adjust for inflation. They never have adjusted for inflation. So even when we were getting indexing for the exclusion itself, those brackets weren't kind of growing at the same pace. And so therefore, you could move through the brackets faster, essentially. And you're going to be moving into higher brackets faster due to not having those brackets also indexed. So as we kind of are looking at this, why is it that this might not be something that you're paying attention to, or that doesn't get a lot of attention? And really, I think we have to remember that we're one state out of 50, and so if you're reading any of the national publications, financial planning or anything, you're going to be seeing a lot of discussion of the federal exemption. The federal exemption is much larger. There's been a lot of action on that also. President Trump did, increase that. There's been talk about it going back down. It's kind of gone around and generally been going up, though. And so we see a $15 million exemption right now. And the other key thing about the federal planning is that you can double it automatically for a married couple. And so that's also something that's out there. And if you're not paying close attention to the fact that that's not the same rule in Washington, you might assume that, in fact, you have the ability to double your Washington exclusion and automatically protect $6 million. And we will see indexing returning at the federal level also. So when that happens, we're going to have another kind of disconnect then between Washington and the federal government. So the big differences are going to be, the lower exemption or exclusion itself, the lack of portability for the state of Washington. So married couples will have to do tax planning in order to be able to use both exclusions. And then also that Washington does not have the indexing on their exclusion amount. So that's our line that doesn't move. So let's look at this a little bit. I'm going to use some examples to kind of show how this would work. And we're going to be talking about really a time horizon of 2036. So when we're thinking about the inflation and calculating your estate tax, we often, when we're doing the planning, we'll be looking at your current estate values. And the reason we do that is we really want to make sure that the planning is appropriate for what you have right now. Now, however, we always want to keep an eye out on where your estate may be going and what we may expect to have happening in that. And so if we projected out where you might be in 10 years, that's what we're going to look at for our analysis today, and whether or not this estate tax and the lack of inflation indexing on that exclusion is going to cause you problems in the future. So let's consider first of all, that $3 million, and what are we talking about? So if you had $3 million and you had an inflation rate of 2.5% over a 10-year period, the purchasing power of that $3 million would be that of a $2.3 million. So essentially your $3 million of assets would be losing $700,000 of its value, its purpose for purchasing other assets. And because of that, one way to think about this lack of indexing is that, in fact, the exclusion is getting lower. The exclusion is staying the same, but inflation does happen, and therefore the purchasing power, the usefulness of that $3 million will be less in 10 years than it is now. So let's kind of also consider what may be happening with your assets. So at the same time that we're not growing that line due to inflation, your assets, however, are continuing to go up in value. And this is just most likely that they are going to be going up in value. So if you had a taxable estate today of $2.5 million, you wouldn't be concerned about Washington estate tax planning here in the year of 2026. But if you were growing at a rate of 4%, your estate was going up by 4%, in 10 years' time, we could expect your estate to be worth $3.7 million. At that point, there would be a Washington state estate tax concern for you. And so, again, if we were doing your planning for you in 2020 or 2036, we would be looking at that and suggesting that maybe planning is appropriate at that point. Because we know that that's going to be something that's necessary in the future, it may be appropriate to start some of that planning early. And then we're just looking at a few other sizes of estates here to kind of see how that would go up. A $3 million estate would be worth about $4.4 million. A $4 million estate would be just under $6 million. And those numbers are the ones that would be used then when we're calculating the estate tax. The $4 million example is pretty interesting because it shows not only the lack of the indexing, it also shows that impact of not having indexing on the bracket. In Washington state, the first $1 million is taxed at 10%. So in that third example, there would have been a $100,000 tax on the $1 million over that. Now, as we look up to the $5.9 million, we can see we're actually going to be going into two different brackets. And so some of that will be taxed at 15%, some of it will be taxed at 16%. And therefore, there's going to be a significant more taxes, not just on the rate that's being, it's not just the rate that's being charged is also going to be going up. But is 4% even a realistic number? So let's look at this a little closer. So in Seattle area, real estate has been on a bit of a tear. Now, we think of this as maybe, is this normal? I'm not sure. But we've seen a 7 to 8% increase per year in Washington on real estate. And it's also been a banner year or banner decade for U.S. stocks. So if we look at the S&P 500, we're going to see annualized returns of 13 to 15%. So is the 4% number even appropriate in your situation? So let's consider what would happen if we were looking at different rates on this. So a $3 million estate growing at 4% would be worth about $4.4 million in 10 years. At 7%, it would be worth nearly doubling at $5.9 million. And at 10%, it would be significantly higher at 7.78%. So depending on your growth rate, you may be in a situation where you're approaching and fast and quickly going past the Washington state exclusion. In addition, you're going up into those higher brackets, as we discussed. And that's really just the power of indexing and going in on this. So as those assets just continue to go up in value, they compound in value. So let's consider what assets are actually considered for Washington estate tax. There's many assets you may consider as assets, but there's also some that people forget to include. So in the count, we're going to include all real estate. This would include your house. It could also include any investment real estate or even vacant lands that you have. We'll also include the value of those retirement accounts that you have, the qualified plans that you have, any life insurance that is owned by you and that is also going to be included in the value. So we're going to look at the face value of that life insurance. This could also include life insurance that's paid out to you. So it could be, for example, a group term policy through work. Business interests, of course, investments, rentals, land that never sold, all of these types of things are going to be in there. Plus personal property, jewelry, gold, Bitcoin, other types of things will be included in that also. Often people forget about the house because they just think of it as where they're living. Once it's paid off, it's not being carried, and that value of it is not being looked at a regular basis. And then we talked about the term policy. We talked about the term policy from work being the group term policy, but it could also be a policy that you have that's just been in place for, well, what happens if I die and I need to provide for my kids, provide for my spouse. And those retirement accounts are sometimes forgotten about too, and other accounts that have just been there and kind of doing their work and not included on our list. So you have to really look at each and every single asset and think, well, is this something that has a value that would be included in my estate at my death? And the answer probably is going to be yes. So let's consider a couple of examples why people might kind of not be aware that they have an estate tax issue. So they bought their house 20 years ago. It's been paid off. Their retirement accounts have they've been adding into it, putting property into it. Maybe they had a term policy to replace income. So it didn't necessarily feel like there was a lot of wealth there. As we start to add that up, if you look at those actual values of those numbers, you can see that they can add rather quickly and get us up and over the Washington exclusion. For a married client, that can be addressed by, for the first $3 million above that, by including planning in their estate plan to create a testamentary trust at the first death that would hold the deceased spouse's exclusion amount, and that would allow us to protect up to $6 million in Washington state. Many of your plans probably have that in it. If they don't, or if you have a question about it, it'd be worth looking into it. We can give you a quick read on that if you send us an email. But if they do have planning, they may not have considered the fact that these other assets are really growing in value also, and they may actually be much higher estate value than they realized. And that's where the Washington tax will come in. We talked earlier about how we might get into the federal habit of thinking of that the spouse can receive everything from the deceased spouse, the surviving spouse can, and that they get to use their exemption also. This is that what is called portability, and it is available at the federal level. And it really is helpful in many states that don't have their own estate tax, because in those states, it would be possible for minimal planning to be necessary at the first death in order to preserve both federal exemptions. Essentially, um, an estate tax return can be filed. We can claim the portability going to from the deceased spouse to the surviving spouse, and the surviving spouse can then protect up to $30 million. It's a really nice taxpayer-friendly rule. It is a rule that I think recognizes that married couples often will want to leave all of their assets to the surviving spouse without having significant amount of restrictions or ties on it. However, in Washington, it creates a problem because in Washington, we are used to community property law. And oftentimes under community property law, people will set it up with what I call a honey, I love you plan, which leaves all of the assets to the surviving spouse. It's as natural as can be for many couples. However, that doesn't allow them to get the protection of two exemptions due to this lack of portability here at the state level. So if they aren't using planning, it essentially becomes a marriage penalty to them, where they are not getting the full benefit of each of their exemptions. Again, if you're not sure if your planning has this in it, it is worth looking into it. You want to see something about a spouse or a trust that's being created for the spouse at the first death. So let's kind of look and see whether this line that isn't moving is worth a second look for you. First of all, if you haven't looked at your planning since the law changes in 2025 and 2026, it would probably be a good idea to look at them. If you've moved, if you sold a business, retired, or inherited property, your assets have changed. And so it's, again, another reason to take a look. If you've had significant growth of value in any of your assets, it, again, was probably worth taking a look at that. If you have not been considering the Washington state exclusion amount and have only been focusing on the federal exemption amount, then definitely take a look and see if this planning is something that you're going to need. And if you're unsure whether you have the provisions in your documents for the Washington exclusion and you are a married couple, then definitely look at that. It's easier to go ahead. It's a pretty easy thing for us to give an analysis of and give you an answer on. So I'm not really predicting what your tax would be here today. I'm not making necessarily a recommendation for any specific type of technique here. I just want you to have some more information about what's going on with this change. I think it's something that's a bit of a hidden trap in the tax law, the Washington tax law, and I'd like you to be able to keep up with that. All right, everyone, we'll be having another presentation next week, actually. I plan on doing a bit more of these every couple every month, hopefully. Next week's is going to be on healthcare documents. And so often an underlooked document or part of the planning. So we invite you back for that presentation. And again, if this has been helpful for you, I hope it has. We will be putting it up on our YouTube channel, and it'll be available there. And if you do have any additional questions, do feel free to reach out to us, and we'll help you with getting answers to those. Thank you very much, everyone.